Good morning, HR. This is Mike Coffey. Today's podcast is a recording of an interview I conducted with Gary Fowler before a live audience at the North Texas SHRM Annual Conference on April 28th. We were using handheld mics, so there may be times where the audio is a little bit sketchy, but I think you'll find Gary's insight into mediation insightful nonetheless. And thank you to John Hagan for the very kind introductions at the very beginning of the recording. And now here's my interview with Gary Fowler.
My name's John Hagan. I'm Vice President of Programs for North Texas SHRM, and I am just beyond delighted to introduce two very close friends who are going to be talking about some legal implications when it comes to HR. So let me start off by introducing my friend Mike Coffey. I think all of you know Mike Coffey. If you don't, I don't know what rock you've been hiding under, but Mike is a SPHR and a SHRM SCP. He's an entrepreneur, licensed private investigator, HR consultant, and registered yoga teacher. So he does the hot and cold yoga. He's president of Imperative Background Screening. They do background investigations and due diligence for different types of clients. He's also state director-elect of Texas SHRM, so he's about ready to be my boss's boss. He's going to be the head honcho for Texas SHRM. And each week he hosts Good Morning HR podcast. If you guys aren't familiar with this, you need to get familiar with it because you can pick up HRCI, SHRM accreditations for these right in the comfort of your own home. And even though he broadcasts on Thursdays, those things are recorded, and you can go back and look at any one of those and still get your credit. So it's a great source for credits. Plus, with Mike's personality and humor, he always makes them very fun. And the other good friend I want to introduce is Gary Fowler. Gary was the Dean of Employment Law, probably still is, of employment lawyers, at least defense attorneys like myself, for the last 30 years or probably longer. I came to know Gary even though he was in a different law firm and actually a competitor of mine. But when I was a young baby attorney, I had a lot of questions. And I ran into Gary and was introduced to him, and he was nice enough and generous enough with his time to answer my questions, even though he was a competitor. But today, his newest format is being a mediator and an arbitrator for JAMS. I don't know if you know what JAMS is, but JAMS is like the AAA, American Arbitration Association. They are a mediation and arbitration provider, and Gary is one of their star mediators and arbitrators. He's board certified in employment and labor law with the with the Texas Board of Legal Specialization since 1994, before I was born. Okay. And he's a fellow of the College of Labor and Employment Lawyers with over 35 years of experience in all areas of traditional labor and employment law. He has served as a mediator and arbitrator since 2015. He is a frequent speaker, and I mean a frequent speaker, on alternative dispute resolution, which is mediations and arbitrations, focusing on discrimination, harassment, trade secret, executive compensation, wage and hour disputes. He mostly worked throughout his career for a fine law firm by the name of Jackson Walker, headquartered in Dallas. And he was co-chair of their labor and employment law section for the 8-year period between 2013 and 2021. And then he joined JAMS. So it is my distinct pleasure to introduce Mike Coffey and Gary Fowler, so let's please give it up. That was kind. I've already lost. There he is. That was kind, John. Thank you. It's better than I expected.
And I would also add that John was kind to say over 35 years of experience. I will tell you at a certain point you freeze it at 35 years because any more years doesn't do any good, and the extra years maybe make people wonder if you still got it. So.
And as you can see, we are recording, so I do need to say good morning, HR. I'm Mike Coffey, president of Imperative Bulletproof Background Checks, and this is the podcast where I talk to business leaders about bringing people together to create value for shareholders, customers, and the community. We are recording before a live audience today at the North Texas SHRM's annual conference in Denton, Texas. And I am joined by Gary Fowler, who is a mediator with JAMS, a nationwide mediation firm, and he's an attorney with, I will just say, 30 plus years of credit to even give you more. And he's also an alumni of TCU, Riff-Ram Bazoo, and Yale Law School. And we are here today to talk about mediation. And caveat at the very beginning here, I'm not a lawyer, and I'm especially not your lawyer. And Gary is a lawyer, and he's especially not your lawyer. So I don't know what the necessary caveats you need to throw in there are, but
General background, of course, many of you probably have your good lawyers that you turn to for legal advice. Please do so. And of course, I'm here as a neutral with JAMS, but any opinions I express are my own and not those of JAMS. So legal part taken care of.
There you go. So we're talking about mediation specifically when there are already lawyers involved. So we've got some sort of either potential or actual litigation. There are probably other kinds, and maybe we can touch on a few of them, of places where a mediator would get involved. But let's just start with what the big scope of what is alternative dispute resolution?
Sure.
What's the big picture?
Well, Texas was one of the leaders in forming alternative dispute resolution. The original statute that enabled us to have ADR in Texas, I think, was passed not too long after I did become barred in 1984. I think the statute was passed around 1989, maybe 91. And the two principal forms of ADR that have come out of that have been mediation and arbitration. We've always had arbitration. Arbitration goes back to the Federal Arbitration Act. Mediation is the way, and we'll talk about this in just a moment, of getting the parties to come voluntarily together to a resolution. When they passed the statute, there were some other means of ADR that aren't used quite as much: non-binding arbitration, summary jury trials. If you look at the statute, there's several different types. But mediation is by far the most common means of ADR that's used in Texas. And now, effectively, if you're in either Texas state court and certainly in Texas federal court, I would say 99% of the judges don't allow you to go all the way to trial without first having gone to mediation. The court will order it. So part of what we get are court-ordered mediations. Part of what we get are voluntary mediations, maybe before the lawsuit is filed. But at least in the world that I operate in, I generally have lawyers. Again, I'd say with very, very few exceptions, lawyers are involved already, and it's gone beyond to the point where there's something wrong and there's a dispute that if the case isn't settled, either a lawsuit will continue or a lawsuit will be filed at least. So what we try to do is get the parties together and resolve that without further litigation.
Will you double click down into the difference between mediation and arbitration?
Sure. Basically, the distinction is that mediation is where the mediator facilitates a resolution that the parties agree to. I don't have any powers. I can't order anybody. I don't judge the dispute when I act as a mediator. When I'm an arbitrator, I fully realize I haven't been elected to be a judge. I realize that no president has appointed me to be a judge. But I do have the power to decide the dispute between the parties because the parties have agreed to arbitration. Sometimes reluctantly, but they have agreed because some of you, and probably some of you, have programs where your employees agree to arbitration as a condition of employment. In arbitration, typically what will happen is the parties will file for arbitration. They will be given the chance to select an arbitrator from a panel that's provided by the provider. In my case, that will be JAMS. If you have the AAA, the panel will be provided by the AAA. And generally, through some sort of process of elimination, you get down to a single arbitrator who is appointed. I say single. Every once in a while, we have panels of arbitrators, but for the most part, particularly in employment cases, it's just a single arbitrator. So in JAMS, let's say, if JAMS is the provider, they will send out a list of 7 names. Often I will be on that list. Sometimes the parties just do mutual strikes until you're down to one person. And of course, some cases, both lawyers will stipulate to an arbitrator, and I get that fairly frequently as well, where both the lawyer representing the employee stipulates and the employer, they stipulate to a particular arbitrator. And so I get cases that way as well. But the main difference is mediation, voluntary result, you're in control. You gotta have 2 to tango, you gotta have 2 to dance to come together. But there are things, and we'll talk about them in a minute, that we can do in a mediation that you can't necessarily get in court or through an arbitration process. Arbitration, I'm much more like a judge, in which I decide the dispute between the parties, and I basically at some point have the duty to provide an award after hearing evidence, as you would in a sort of trial type procedure.
So are arbitrators and mediators generally experts in one area of law or industry or kind of cause of action?
There are many that do. At JAMS, a lot of our arbitrators are judges. I think John asked me what JAMS stood for, and I think it doesn't stand for anything anymore. I think it is JAMS, J-A-M-S, The original acronym was Judicial Arbitration Mediation Services, because JAMS was originally founded by former judges in California and then spread throughout the country. At some point, they decided to, scrape the barrel and let people like me in who have never been a judge. So we now have neutrals with JAMS who are both former judges and have generally been attorneys. In my case, 90% of what I do is still labor and employment. I was a labor and employment lawyer, as John was pointing out. Was board certified. I headed up the labor and employment section. I specialized in labor and employment law. So I'm known to be an expert in labor and employment law. Judges, of course, tend to be more generalists. They've seen everything, but they have the unique perspective of having been judges. Some people really specialize more in just the art of ADR, and they may do a variety of different areas. But yeah, certainly we have people who specialize in family law. God bless them, that's got to be some of the toughest work. You have one of our specialists at JAMS specializes in probate work. We have a former bankruptcy judge. So yeah, like lawyers, we often do tend to specialize in our particular areas. I'd also say in the arbitration realm, you see people, and here a lot of times you see non-lawyers who are construction specialists or architects. In the traditional labor, when I say traditional labor, I mean union management. You have non-lawyer arbitrators, but there you have a collective bargaining agreement, and some labor arbitrators are former judges, former attorneys. A lot of them are professors, and so you do get more of a variety in who does arbitration in the labor arbitration world.
So we've got, I guess, 3 options. We go to court
Right.
and roll the dice and hope we can make our argument and convince a jury or a judge that we deserve that outcome. We go to arbitration, basically do the same thing, but let an arbitrator decide. Mm-hmm. Or go to mediation and we try to get the parties to agree to something short of going to court.
Yeah, and I'd say mediation is often the common denominator of both of those. I mean, generally you will only have arbitration in the context of where prior to the dispute the parties have agreed to arbitration. And there are some exceptions now to pre-dispute arbitration being binding. Congress passed a law a few years ago called the Ending Forced Arbitration Act, and on cases alleging sexual harassment or abuse, pre-dispute arbitration clauses are at the option of the employee, no longer valid or no longer binding. But that has not generally applied across the board to all employment arbitration. But mediation, oftentimes you will still mediate a case that is ultimately headed to arbitration. I had one last week where we settled the case, and it otherwise was going to go to arbitration, I believe, around the 1st of June. So you can do mediation even where you do have arbitration.
And why would I want to go to arbitration instead of court? And then why would I want to do mediation instead of arbitration?
In terms of why, and clients would ask me why, every once in a while, a client, when I was practicing, generally representing employers, I also represented executives and occasionally would represent an employee. But the majority of my practice was, particularly on the advice side, was on advising generally clients that had first come to me with a lawsuit, and at some point after the pain of a lawsuit, they said, "Isn't there a way we can avoid this?" Well, I'm always here for consultation on the front end. And so my regular clients would consider arbitration programs. I'd say the advantages of arbitration are that it does tend to be a process that ends more quickly. A case that starts in arbitration will be finally decided within 15 to 18 months, and I know that sounds long, but you compare it to a lawsuit in federal court or in state court, and with appeals, you could be 2 years, 3 years, 4 years, 5 years. If the case gets reversed, the Court of Appeals comes back, sometimes you see that ones that are dragged out 10 years. So it's a more expeditious process. You can also, within certain limits of fairness, control in advance how much discovery you will have in or at least provide guidelines to the arbitrator in that regard. The rules of evidence are to some degree relaxed. That will again depend upon the arbitration agreement. Another advantage that I think is often overlooked is if you have a hearing date in arbitration, you will go that day unless both you and the other side agree or the arbitrator grants a continuance. If you have a case, I don't know how many of you have had the pleasure of having a case go all the way to trial, but in trial, a judge has 50 cases set on their docket for a particular Monday. You can be set for trial. I had one case one time that was set for trial 5 times. And we got ready for trial 5 times. That's costly. And every time we got set, the judge would call his criminal docket and we'd get bumped to the next month. With arbitration, you're always number 1 on my docket. There is nobody else scheduled that day. So you tend to go that day and at that time. I think some people could conceive that arbitration is more pro-employer. I disagree with that firmly. I believe we are neutral. I believe that I and my colleagues and my fellow arbitrators consider every case. And so I would tend to disabuse people of the notion that arbitration is somehow more pro-employer or less pro-employee. You do get a reasoned award, with a jury. You get answers to questions, so you do at least see the reasoning behind it. Disadvantages, there are some additional costs with arbitration, although I think they're made up by the lower attorney's fees, particularly if you consider how many times you may have to get ready for trial. But arbitrators charge fees. You've paid for judges with your tax dollars. The American jury system is a great system. I would never say anything against the American jury system. You don't have a jury in arbitration. And you know, as I sometimes, to make a point, hopefully humorously would say, the words arbitration and arbitrary have the same root meaning. And I found a lot of times that, you know, if people lost in arbitration, they tended not to like arbitration at that point. And there is no appeal, generally. You can provide for an appeal in your arbitration agreement, and we do have occasionally at JAMS an agreement that says, you know, the arbitrator's award will be final, except either party may appeal it to a panel of 3 more arbitrators for an appeal. If you really want to preserve an appeal, that's a good idea, but of course in doing that, you're going to be increasing your costs if you have that. So I think in considering an arbitration program, you have to balance efficiency, cost, and how much of those additional protections you want. Why would you go to mediation? Well, with mediation, we'll talk about some of the non-economic things. When I sit as an arbitrator, I'm generally looking at things according to who has the best case, who has the best facts, who has the most persuasive evidence. I'm looking at it more or less the way a trial judge sitting on the bench would look at. In mediation, yes, all those things are important, but I'm also looking at what are the underlying interests here. What's the best way we can get to a resolution that addresses what the parties really need and really want? In the words of that great mediation philosopher, Mick Jagger, you can't always get what you want, but sometimes you get what you need. And I think that's particularly true in my work. In addition to mediating discrimination cases, executive contract, wage and hour, I do a lot and was particularly a specialist in covenant not to compete in trade secret cases. And there I'm very much looking for what is the protection that the former employer needs in terms of what information this employee might have. You know, let's say you have 2 large healthcare companies on both sides. The employee left was working on a special project. Healthcare company 1, the former employer, is very concerned about how that information might leak over to 2. How do we address that? And we look at things like what are the duties during a short period of time, a relatively short period of time. There are various non-economic things we can do, particularly in the context of mediation, to get at a solution that addresses both parties' business needs and also allows usually these cases involve executives or very high-level researchers, that allows them to, of course, go on with their career. And so with mediation, you have much more flexibility, because ultimately, again, it's the 2 parties who are going to arrive at the solution. A judge in that case, an arbitrator in that case, and oftentimes when I have them on the arbitration side, I will tell parties, you know, whatever solution I give you probably won't be as good as one that you can arrive at through your own resolution. And that's why I think you particularly want to go to mediation. In more in more cases that we probably see more often, in a discrimination case, you want to mediate a case because to avoid cost. I mean, there is a lot of cost to trying a case, particularly in court and even in arbitration. And the cost isn't just paying the attorney's fees. And you know, as much as I know all of you delight in making sure your attorneys are paid well for their services, you know, there is a disadvantage to that, and that's to your budgets and things of that nature. But the thing I often emphasize in mediation is not just the attorney fee costs, it's the time, the distraction, the worry that people who are involved in these cases, they must devote time to depositions, and it's just distracting to have the specter of a lawsuit hanging over your head. So there are non-economic costs that you want to try to address. And what mediation does, and the reason why our legislature went for it in the late 80s, was cases used to tend to settle on the courthouse steps. Mediation pushes that day of reckoning forward. And by getting the parties there with a neutral, who by asking questions, asking positions, not necessarily giving you a judgment, but at least causes the parties to start thinking about how a neutral arbitrator may look at this, a neutral judge may look at this, or 6 to 12 people sitting in a box that we call a jury might look at this. And by looking at best case scenarios, worst case scenarios, and inherent costs of win, lose, or draw, you hopefully get the parties thinking about a resolution early on before those costs are incurred.
And according to Texas Lawyer, article from 2019 from somebody at JAMS,
Cecilia Morgan, yep.
About 80% of cases get settled in mediation.
Yeah, I would say that's about right, and particularly if I would say day of, for me, it's probably closer to 65 to 70, but I stay with the parties when a case doesn't immediately settle, and a lot of them we do settle in the 1 or 2 weeks after mediation, or sometimes, in choosing the time to go to mediation, there's always a bit of a, finding that good Goldilocks moment when you know enough that you can really evaluate your case, but not spend so much on discovery that, you've spent so much now that it's hard to settle the case. Occasionally, when a case is mediated early on, the parties sometimes just need to go do some discovery. And so in those cases, parties may say we need to go do some discovery, and then we'll come back to mediation for, usually a shorter round or at least a follow-up call with the attorneys and things like that. But generally, your case is going to settle. Doing it more quickly on the front end is generally going to cost you less than letting the case go all the way to the eve of trial, or even finding out what the jury has to say about your case. So, some cases obviously need to be tried, and when I mediate a case, that's always an option. I mean, I talk about door number one is continuing through litigation. What does that door look like? What are the costs? What are the inherent costs? What are the risks? Door number two is resolution. Some cases do have to be tried, and that's why we have courthouses.
So if I go into mediation, how is confidentiality ensured so that I can be honest in the negotiation and not worry about it biting me or getting out in the newspaper the next week or to the union rep in our warehouse or something?
Well, labor arbitration contests I may address separately because it is a different context in that regard. But in the mediations which are court ordered or where you have attorneys on both sides, the mediation agreement and the statute that I referenced, Chapter 154 of the Texas Civil Practice and Remedies Code, provides that mediation is an entirely confidential process with very, very limited exceptions. I mean, generally there are exceptions for elder abuse, child abuse, unfortunately things that probably do occur in the family law mediation context, thankfully not in mine. So basically it is a process where it's a black box. What goes into the mediation doesn't come back out. And the example I generally give parties, if this is a car wreck case and one of the parties admits they ran the red light during the mediation but doesn't admit it anywhere else, can't stand up at trial and say at mediation they admitted they ran the red light, Your Honor. In that sense, it is confidential. Why do we have that? Well, we have that for the very reason you suggested, Mike, and that's so the parties will be fully forthcoming without having to worry about what they say that day may be used against them. So confidentiality is important in that regard in the context of, I would say, post-dispute type litigation. The other way that it's confidential is at a typical mediation, we may or may not have a full joint session where the parties actually talk to one another. Lawyers have tended to get away from that in post-dispute mediation, for better or for worse. And so a lot of what I do are in individual caucus sessions. And I tell the parties that if you don't want me to share something with the other side, tell me, and I won't do it. I will keep that confidential. and otherwise, that's the rule.
So they're in two separate
There are
conference
two separate
rooms
rooms,
in
and
your
I'm
room.
generally playing shuttle diplomacy between the two rooms. The other way that it's confidential is the judge only gets a report that says the case settled or not settled. If no judge would ever do this, but if a judge called me and say, well, tell me what the party's last offers were, or tell me who you think was more reasonable, or who do I need to really get after, I'd say, Judge, I can't do that. And no judge would ask me that question because they know that already going in. So it's confidential in all three respects of that term. You can't be used in evidence. What you tell the mediator, if you tell him to keep it confidential, remains confidential. And third, the judge only finds out settled, didn't settle, still working. It's basically the three boxes on the form. Now, I will say it is somewhat amusing sitting as the mediator that a lot of times I'll be in one room and they will say, we want you to keep this confidential because we don't think they know X, Y, Z. More times than you'd think, I go into the other room and they say, the other side doesn't think we know this, but we know X, Y, and Z. So, you know, sometimes what you think is unknown to the other side winds up not being actually unknown to the other side. So, you know, and I'd say to the extent you do mediation in other contexts, let's say you bring in a mediator who maybe is a lay mediator with regard to a workplace situation, think about in advance how you want to handle confidentiality because, you know, I haven't completely thought it through. Again, can't give legal advice today even if I had, but, you know, you may want there to be some report from the mediator. Particularly a workplace facilitator. But you also need to be real clear, both parties understand how much is confidential because I think when you, in the world I deal with, again, it's post-dispute, we've got lawyers, it's serious, but I know a lot of you will engage mediators or workplace facilitators who may have had their mediation training. And I would urge you to look at your confidentiality agreements and make sure everybody has a clear understanding of how this might be used later on if things don't work out or if we go to court, and what's really expected of the parties in confidentiality there. Because that's a different, and that's frankly a different context than what I'm dealing in. Because again, I'm post-dispute. It's a situation that's headed for a lawsuit by the time I get involved.
And is the confidentiality that goes beyond, you know, whether it can be used as evidence or used by the court or anything, is that confidentiality, does it extend to the parties not being able to tell their friends and other people? And then how do you enforce that?
Well, usually your mediation agreement will require them to do that. You know, how do you enforce that? Well, you know, ultimately you might have to go to court to do that. Some degree, yeah. I mean, obviously, if you're in mediation and you say we have documents that show, you know, when this particular event occurred, or you share an email, well, yeah, technically, the other side's not going to be able to take that from the mediation and use that email if they, you know, take a copy with them. On the other hand, they can send a request for production after that says, please send the email of July 21st, you know, 2021, and, you know, that evidence that comes out independently, of course, would still be discoverable and useful.
And how often does that really happen? How often is that an issue?
You know, well, I don't know. I mean, fortunately, I don't have to deal with discovery anymore. That's one of the advantages of my current job. I will tell you, if they told me about discovery when I was in law school, I probably would have done something useful with my life, like be an HR director. The discovery was the bane of my existence, and I'm glad not to have to deal with it. But I think the parties, for the most part, treat confidentiality seriously. I know the judges do. If a judge thought it was being breached, that is probably not the way to impress your judge. Because this is an important, or your arbitrator, because we all recognize this is an important process. And like I say, no judge, very few judges in Texas will allow a case to go to trial without it first going to mediation.
how often for the complainant is money the big factor versus some other intangible thing that, that they want to get out of this process? And money is, they've got to sue for relief, but that's not really what they're looking for. And can they get whatever it is they're looking for in mediation?
Yeah, I think that's where we can address those concerns. Obviously, it varies from case to case. I would say, some sort of monetary compensation, at least in what I deal with, is a key part of most, if 90, 95% of the mediations. But there are other things that are important, particularly in the context of employment law. I think a lot of times things that I see that are non-economic things, is a termination with cause. The employee will ask that the records be amended to say that the termination was without cause. I'd always be careful with your attorney on that in agreeing to that, because you may not want to, your attorney may advise you, again, I'm not going to give legal advice, but your attorney may advise you, yes, we can now have a later document that changes it, but generally you don't want to be destroying or altering employment records. But sometimes that's asked for. Sometimes employees will ask that you not contest unemployment with the TWC. Obviously, those are cases that are mediated earlier on because that's still an issue. TWC doesn't have to abide by that because they're protecting the unemployment insurance fund, but oftentimes they will. Other things that are asked for is, if not a positive letter of reference, at least a commitment to abide by a neutral reference policy. Particularly in harassment cases, or if the EEOC is involved, either the EEOC or the employee will ask that the employer commit to new training, generally on harassment or disability or related issues. And one thing that is useful in mediation, generally those sort of things can't be ordered by a court. You go to court, and there are some injunctive relief things that can be granted by a court, but for the most part, all a court or an arbitrator can give the employee is money. And what you can get in mediation are some of these things that are very important in, let's say, a discrimination case primarily, or a harassment case, or a retaliation case. In the context of covenants not to compete, as I alluded to earlier, generally those cases, particularly early on, when an employee has just moved, money is not a big factor. Covenants not to compete, or the factors in Texas are time, geography, and scope of activity. Well, I'm generally mediating those cases according to time, geography, and scope of activity. Money oftentimes gets thrown in almost as just, the little floor mats that make the case go ahead and settle. We'll pay $50,000, and we'll keep the employee away from, working on the widget project for 6 months, and we'll pay $50,000 in attorney's fees. But it almost gets thrown in as sort of swag or a freebie at the end. So in those cases, yeah, you're dealing mostly with non-economic factors in trying to get the case resolved. But I think it's important also in other cases. Wage and hour cases, well, those tend to be our answer to math problems, and those, I'd say, they generally are almost all money in that regard. Just because of wage and hour case, they're usually requesting overtime or off the clock or some sort of allegation that really only addresses money. I suppose you could maybe have a case where somebody wants you to do additional training, or if the Department of Labor was involved, maybe they would want the employer to do additional training, but not as big a factor in wage and hour cases.
And let's take a quick break. Good Morning HR is brought to you by Imperative, bulletproof background checks with fast and friendly service. If you're an HRCI or SHRM certified professional, this episode of Good Morning HR has been pre-approved for 1 hour of recertification credit. To obtain the recertification information, visit goodmorninghr.com and click on Research Credits. Then select episode 200 and enter the keyword Fowler. That's Fowler. And if you're looking for even more free education and recertification credit, check out the webinars page at imperativeinfo.com. And now back to my conversation with Gary Fowler.
So let's say, okay, we're the company and we've decided we're going to agree to probably to mediation. What's that process? You know, you touched on it earlier, but if I'm trying to evaluate, I've got a list of mediators, and are these, you know, are these typically a list of mediators that the court has approved for this, or is this just, you can just go, you know, the court's going to refer you to mediation, and y'all go figure out who's going to settle it for you?
Yeah, certainly in what I would call the post-dispute world that I work in, generally I'm chosen by the attorneys. And so two attorneys will get together and say, who do you like as a mediator? And or who do you think would be good to mediate this case? And so typically the way I get a mediation is the two attorneys have agreed upon me to be the mediator. Courts do appoint mediators, particularly when the parties don't agree. And so sometimes it is through court appointment, and in that case, judges do have usually sort of an approved list. Most judges now, in my experience, will say to the parties, you have a deadline to give me a name by this date, and if you don't, then I will appoint someone. But I would say, you know, I've been at JAMS 3.5 years. I'm probably right at about 100 mediations in 3.5 years, certainly getting a lot more now. I would say my court appointments are probably about 5, and the other 95 were the parties agreed to me as the mediator. What do you look for? Well, I think it depends on your case. Obviously, one thing I guess that parties hire me for is not my looks, but you know, because I did labor and employment law for a long time, and I know the law. You know, other factors, I mean, sometimes you do want to judge. You want that gravitas that somebody who is called your honor by everybody lends to a particular situation. So you may want to have a former judge. There may be a particular style of mediator who attorneys think are particularly good in particular types of cases. Let's say it's a harassment case or a disability case or something like that. So I think you look at those factors, and of course you also have to look at availability and maybe to a lesser degree cost. You know, if you're needing to mediate it right away, well then availability gets to be a much bigger factor. If you've got more time, then obviously that's not really a factor at all. So I think you look at all those sort of things, and your lawyer, you know, and talk to your lawyer about who do you think would be the best type of mediator for this particular case, and who would be most likely to facilitate resolution. And I think we all have our styles. I tend to be more of a, well, I tend to be almost 3 people during the course of a day. I'm a listener at the beginning. I probe sort of the middle part of the day, and at the end of the day, I'm getting a little bit more evaluative and telling you, you know, really, I think you ought to make this move, or why don't you consider this move, or do you really, you know, if you want to get this case resolved, you know, and so get a little bit more that way.
And who's going to foot the bill for the mediation typically?
It's typically half and half, although certainly on early mediations, I sometimes see the employer has paid the entire bill. The good thing about my working at JAMS is JAMS handles all the money, so I don't necessarily know who's paid and who's paid what. But I would say typically on a court order mediation and a pending lawsuit, it tends to be half and half. Sometimes at the end of the day, when you're really close, you know, let's say the case is down to 150 versus 155, the case settles by, okay, we'll pay the 150, but we'll throw in reimbursing the, you know, the mediator costs, and that gets to be the meeting in the middle that gets you done at the end of the day.
So as a mediator, how much information do you have before you walk in on day one? How much prep do you have, or are you just being introduced to the facts?
Yeah, I think mediators vary in that. I do quite a bit of work before the mediation. I do a pre-session call. Generally, I want the pre-session call, frankly, to generally be only with the attorneys. certainly welcome for clients to be there. But during those calls, attorneys will sometimes tell me things that are more difficult to say in front of their clients. You know, they do get along with the opposing attorney. They don't get along with the opposing attorney. It's a non-compete, and I drafted the agreement. You know, I need to know that in front of him before I start, you know, picking at the agreement that they drafted. You know, sometimes they will talk about their frank opinions, maybe if they've already been in front of the judge, which is more difficult to say in front of a client. And so generally those pre-session calls are with the attorneys. Most parties will also give me a mediation statement, which is much more, you know, generally has facts, law, exhibits. I will certainly read that and study that beforehand. So that's the prep work that goes in before the mediation, is generally reading that. If the case is already an existing lawsuit, I will look at the docket sheet independently and just see if there's anything else that hits me when I look at the docket sheet. I want to know, you know, what the status of the parties are in terms of existing settlement negotiations. I also asked during the pre-session call, does anybody have a hard stop? You know, if we're going to mediate this from, you know, 9 to 5, does anybody going to have a flight at 6 p.m. We're going to, you know, all of a sudden somebody jumps up and leaves at 4 o'clock? Well, that's not good. So I have a checklist of things that I cover in those pre-session calls. So that's the work on the front end. And then, of course, you have, sometimes if the case doesn't settle the day of, you have some post-session work too. I urge, particularly in employment discrimination cases, for both parties to bring a settlement agreement with them, because you generally, if possible, if you arrive at the number, you arrive at what other key terms are, it's just going to be better, and I'm certainly willing to stay to get it done, to get the full agreement signed that afternoon, that evening, rather than sending the parties home and then people get buyer's remorse, you know, whatever. And sometimes deals that are made can at least then be more difficult to finalize. So I urge parties in those pre-session calls to bring a settlement agreement with them.
How often does either I live in Fort Worth, and our ugly neighbor to the east, Dallas, is kind of famous for being
I went to TCU and practiced in Dallas, on that too, I am neutral.
Okay. So, but they do have that. Dallas County has more of a reputation as being pro-employee, and I know that's a reputation. I don't know if it's true. And Fort Worth, I think, or Tarrant County has the idea that maybe it's a little bit more pro-employer, pro-business. How often does either the venue or maybe the particular judge that you're before affect how the parties might be persuaded to, you know, do you really want to take your chances before Judge McBride back in the days? Lawyers like to talk about that. I will say the number one determining factor on a case are the facts. I clerked, had the great pleasure and honor of clerking for the United States Court of Appeals for the Fifth Circuit when I got out of law school. Obviously a different day and time. Go ahead and admit it here, 42 years ago. At that time, I think there were about 7 judges that had been appointed by President Reagan and about 7 judges that had been appointed by President Carter, give or take a few. Even, I think we had an Eisenhower and a Johnson and a Nixon and a few others in there too, of course. But 98% of the cases, the judges agreed upon the result, no matter who appointed them, whether they were pro-employee, pro-employer, conservative, liberal, whatever. 98% of the cases are, any judge will look at it. So I think to some degree we tend to overemphasize that. And so in mediation, I would probably say, what do you think of your venue? What do you think of your judge? Have there been any rulings so far? Again, going back to the example of a covenant not to compete case, a lot of times those have a preliminary ruling on temporary restraining order or temporary injunction.
through that, you may kind of find out what your judge thinks of your case so far. And so that's certainly something that's directly relevant. But I would tend to minimize and give y'all hope and the courage that in our American justice system, judges do generally reach the same result based upon the facts and the law in front of them. And so I don't view that as that big of a factor.
Nice. So we're going to mediation. What do I do to prepare? What is that? What does my roadmap to preparation look like?
Well, I would say, and if you want the, I think we're about to run out of time there.
We've got 10 minutes.
Okay, great. Okay, just checking.
Watching.
I'm sorry, the question again?
Oh, hell, I forgot.
What did it prepare? Okay, yes. My number one pet peeve, please try to persuade whoever has the real authority to come to your mediation. I know many of you probably get put in this conundrum because what tends to happen sometimes is you all will get together before the mediation, before you've heard from me, before you've heard me doubt your wonderful argument on promissory estoppel or whatever it is, that your attorney, of course, doesn't want to show that they're chicken. They want to tell you they believe in your case and they're all with you 100% and we're going to go get them. And you all agree that the case our top dollar should be $40,000. And so whoever comes to the mediation shows up with $40,000. And after listening to a day of mediation and working, well, maybe now we think it's $60,000 or $70,000, and
I'll sell it for 40 in a bag if you just give me the cash.
Yeah, okay. If you don't have but then you call your CEO or your general counsel or whatever, and they're like, what? Well, I thought we said 40,000. What are we talking about 60,000? That makes it very hard to settle a case. So having the people there that truly have the full authority. Mediation should be a listening process where you all are open to considering your preconceived notions of a case. And if the people there don't have the authority to act upon what happens in the mediation process, that makes it much more difficult. And of course, with some judges, you may not be in compliance with that judge's order. And you mentioned Judge McBride. I remember years ago, Judge McBride, I think, had a case, I want to say it was with FSLIC or FDIC. I could be wrong with that. And this was something I never really saw printed, but just sort of heard about. That unfortunately, whoever showed up for that agency admitted in a deposition that, well, yeah, I have authority, but authority only to go up to this number. And Judge McBride was like, well, no, my order was for you to have full authority. And the person, I guess by then they were in front of the judge, and he said, well, the only full authority would be the entire board of the FDIC. Well, guess what? Judge McBride ordered the entire board of the FDIC to attend the mediation. So you've got to also be in compliance with your court order in that regard. And if state judge, federal judge, but as I said, I clerked for the Court of Appeals, and my judge told me one day that I didn't know the power of God Almighty on this earth till I saw a United States federal district judge.
I've heard that many times.
Yeah,
So what other preparation? Having the authority and who?
Having the authority, I think, is key. I would say meet with your lawyer, make sure you've discussed the case, make sure you're familiar with the mediation process. Just some incidentals. We generally do serve lunch on a full day mediation. We do some mediations by video conference. Obviously, during COVID, we did them all by video conference. The good part of that was I think we discovered how having video conference as an option could really facilitate the process. And I'd point out two ways that is so. First of all, I just talked about authority. Let's say you have EPL insurance in your case, and your claims examiner is in Connecticut, and the EPL insurer doesn't want to pay for them to fly to Texas. Well, you can have the EPL insurer there by video conference, even if the rest of you are in person. We call those hybrid mediations. So it helps in that regard. Secondly, it also helps in certain types of cases. I can recall, when we just presumed we had to be there in person and never really thought about it differently. And harassment cases, we would have these elaborate procedures to make sure that the accused and the harasser wouldn't see each other, talk to each other, run into each other in the bathroom, at lunch, all that sort of thing. And of course now, again, we could have one of those parties or both of those parties participate by video conference. I think video conference is also an option just where cost is a factor, just because you don't have travel costs. I think I lean toward, and I think every case is different, so you have to think about each one. And this is what I think you should do in your preparation. Is this case better for video conference? Can we accomplish what we need to do? Or are the emotions so high in this case? I'd say the more emotional the case is, the more I'm going to want to be with the parties to deal with that rather than just dealing with somebody on a screen. So I think all of those are factors, just as well as making sure your attorney has what you need, what your attorney needs to transmit to me. I will read anything I get within the time frame you give it to me, but I sure appreciate it coming 2 days before rather than at 10 p.m. the night before the mediation. And a lot of times I get these very nice 20-page mediation statements that are sent to me at 10 p.m. the night before, and frankly, I'm going to maybe be able to do one read through on that before we get to the mediation conference itself. So far better to get those materials to me as early as you can. And I realize sometimes there are factors that prevent that.
So the attorneys are there.
Attorneys are there.
Somebody
generally.
with authority to make a decision.
Yep.
What about fact witnesses? Or
No,
anything like that?
generally you're not going to have, I mean, if you have somebody who has really technical knowledge that you need to have there to answer questions, a lot of times I'll see somebody bring somebody like that. Let's say you have a wage and hour case and we're dealing with 200 employees, we might have a payroll specialist there, but more just so we have the information readily at hand to deal with the numbers and to crunch the numbers.
What about?
But we're not going to take testimony. We're not going to swear people in. We're not going to lock them in a room and tell them they can't go out. Anybody's free to leave. Very rarely does it happen that somebody leaves before, I call an impasse or we have a deal. But you're there to negotiate in good faith. And generally that's what will be required in your court order, that you have somebody there with full authority to negotiate the case in good faith.
And on the complainant side or the plaintiff side, what about that employee or former employee's spouse or, their spiritual advisor or whatever they've got?
Yeah, and
Bartender.
I had one last week where a spouse was there and it was very helpful. I've had one where I made a mediator proposal at the end of the day and the spouse walked over to me and tore it up in front of my face. And I said, well, I guess that's a no. I will say that I called the lawyers 3 days later and we got the case settled. So that one had a happy ending. They can be negative factors, they can be positive factors. Like I said, the one last week, it was an extremely positive factor. I would say if they're absolutely essential and the party is not going to be, willing to settle the case without their spouse there or their minister there or their friend there, then sure, yeah, have them there. Make sure they sign off on the confidentiality agreement and they understand the confidentiality process. And at JAMS, my case manager takes care of those sort of administrative tasks. But if somebody's essential to the process, have them there. I don't fight the person being there. I do appreciate the heads up that they're going to be there.
So you've worn out the carpet running back and forth between two conference rooms all day long, and now you see a solution. Is that where the mediator proposal comes in?
Well, there are various techniques that you may see in a mediation. I tend to use what are called brackets, particularly on the monetary numbers. The reason why you use brackets, it tends to allow the parties to move more quickly without necessarily looking like they're giving too much ground. We could do a whole session on brackets, and I don't have time to go into all the math and all that, but I would say probably in about half of my cases, we will use brackets that go back and forth, where you're looking at the midpoint of the two brackets to really see where the parties are. I will do a mediator proposal if requested by the parties, or if I have the situation, which I alluded to earlier, where the people at the mediation are pretty committed to being at a higher number, but they need to go back and sell it to the other side. Occasionally, the employee's lawyer will ask me to make a mediator proposal because hopefully I've built good rapport with their clients during the day. And the plaintiff's lawyer really wants to recommend the number, but wants the cover of a mediator proposal to help them sell it to their client. So all those, and a mediator proposal, just very briefly, and again, we start getting the math of this, we'd be here for much more time.
When a lawyer who's used to charging by the hour says very briefly?
Yeah, I don't anymore. It's flat rate, for the most part. Mediator proposal is mediator makes a proposal. The number, let's say the number is $100,000, and the parties have a certain time. If both parties say yes, you've got a deal. If both parties say no, you obviously don't have a deal. If one side says yes, the other one says no, then obviously the yes party knows that the other side said no, but the no party doesn't know that the yes party said yes. Does that make sense? Okay.
Yeah, that's real clear. Well, if that's all the time we have.
Well, thank you. I've enjoyed doing this, and I hope it's useful to our audience here and to your listeners.
Thanks for being here, Gary. Appreciate
Okay,
it.
thank you.
And that was my conversation with Gary Fowler, recorded live at the North Texas Annual Conference. Thank you to Gary and the conference team for the opportunity. Also, I don't want to end the episode without celebrating the fact that this is episode 200 of the podcast. I wasn't sure we'd get past episode 12, so I'm kind of amazed that we're here. Thank you for listening over the last several years and for all the kind comments and suggestions you've sent. It's a better podcast because of your input. And thank you to all the guests who've suffered through my sometimes clumsy interviews. And as always, don't hesitate to reach out if I can be of service to you personally or professionally. I'll see you next weekend. Until then, you know the rest. Be well, do good, and keep your chin up.